In today's legal landscape, an unfolding controversy has captured the nation's attention, centering on a scandal involving a private signal chat used by high-ranking officials. This report examines the details of the case, the courtroom developments, and the broader implications for accountability within the executive branch. At the heart of the matter lies a lawsuit that questions whether key government communications have been preserved as mandated by law, a question with significant implications for national transparency and security. Earlier today, a lawsuit was promptly filed before Judge James Boasberg in federal court. The suit, brought by American Oversight on behalf of concerned citizens, challenges the record-keeping practices surrounding a signal group chat that allegedly contains discussions on war plans and imminent military operations. The dispute has raised serious legal and procedural questions about the administration's handling of official communications and its compliance with federal record retention laws. During a brief 20-minute hearing, an unexpected development took place. The parties involved reached an early consensus on how the case should move forward. Representatives for American Oversight and attorneys from Donald Trump's Department of Justice concurred on a procedural approach that effectively acknowledged a critical point. In their pre-hearing memorandum, the DOJ lawyers conceded that the records in question were already being preserved. This admission was significant as it suggested that the very communications under scrutiny, discussions via the Signal app, had been documented and stored in anticipation of potential legal challenges. The legal rationale behind this SWIFT agreement rests on two foundational statutes: the Federal Records Act, FRA, and the Administrative Procedures Act, AP. Both statutes require that any records generated by federal officials, particularly those involved in discussions of military operations and national security, must be promptly retained and transmitted to the National Archives. This legal framework is designed to ensure that all official business is documented and accessible for future review, including through Freedom of Information Act, FOIA, requests. Requests are a vital tool in maintaining government transparency and holding public officials accountable. According to the complaint, as articulated in paragraph 61 of the roughly 20-page document filed by American Oversight, the defendant's use of the Signal app by figures including Secretary of Defense Pete Hegseth, Tulsi Gabbard, John Ratcliffe, Marco Rubio, and others poses a substantial risk. The claim is that by employing a private messaging service for discussions that should fall under official record-keeping, these officials have potentially violated the statutory requirements for record preservation. In essence, the plaintiffs argue that these communications are not only of historical importance, but are also legally mandated to be maintained. This allegation forms the cornerstone of the lawsuit, a clear assertion that the administration's failure to adhere to these laws must be rectified through judicial intervention.
The DOJ's response in the courtroom was equally telling. Prior to the formal hearing, their lawyers admitted, via written memo, that a restraining order was unnecessary because steps had already been taken to locate and preserve the disputed Signal chat, TET. Notably, one agency had already identified and archived a partial version of the communication record, a detail that raised further questions about the completeness of the preservation process. Judge Boasberg, known for his measured and incisive courtroom demeanour, observed the developments with a sense of calm authority. He expressed his intention to start the proceedings by establishing common ground between the disputing parties, a move that underscored his understanding that the DOJ was, in effect, acknowledging the veracity of the plaintiff's concerns. In a particularly pointed remark during the hearing, Judge Boasberg assured the DOJ attorneys that the oral order he was about to issue would be formalized in writing. This was not merely a procedural matter. It was a clear indication that the court intended to maintain strict oversight over the preservation process. The written order stipulated that the defendants must use all available resources to preserve every Signal communication from March 11th through March 15th. Additionally, the order required that by March 31st, the defendants file a status report, complete with sworn declarations detailing the steps taken to secure the records. This measure, set to expire on April 10th, serves as a tight deadline designed to ensure prompt compliance and to keep the administration accountable. The implications of these developments extend well beyond the immediate legal contest. They strike at the heart of a broader debate over governmental transparency and the extent to which executive actions should be subjected to judicial review. Critics argue that the Trump administration, by resorting to the use of a private messaging app for sensitive communications, has skirted its legal obligations. The swift filing of this lawsuit reflects a deep-seated concern that government officials may be using digital communication tools in ways that compromise the integrity of official records. This case also highlights the complex dynamics of accountability within the current political climate. On one hand, there is a growing chorus of bipartisan voices calling for greater scrutiny of the administration's practices. For instance, a joint demand by a Republican and a Democratic member of Congress has urged the Department of Defense Inspector General to investigate potential abuses linked to this signal chat. However, critics point out a significant irony. The Trump administration has already dismissed the Department of Defense Inspector General, a move that has left an important watchdog position unfilled. This gap in oversight raises questions about the administration's willingness to hold itself to the same legal standards it expects of others. Further compounding the issue are the comments suggesting that the administration prefers to secure its records only after the fact, rather than implementing robust, proactive preservation measures. Observers have likened the administration's approach to a scenario in which officials opt to ask for forgiveness rather than seek permission, a stance that effectively undermines the spirit of transparency and accountability enshrined in federal law. This incident, it is argued, is emblematic of a larger pattern where critical decisions affecting national security and public trust are handled with insufficient regard for established legal norms. As this case continues to unfold, the role of independent watchdog organizations such as American Oversight and the ACLU becomes increasingly vital. These organizations are not merely critics, but are actively engaged in ensuring that the actions of the executive branch adhere to the rule of law. Their efforts, combined with those of state attorneys general and other non-partisan groups, serve as a crucial counterbalance to any perceived attempts by government officials to evade legal responsibilities. By vigorously pursuing legal action and demanding transparency through FOIA requests, these groups aim to uphold the principles of accountability that are essential in a democratic society. The ramifications of this lawsuit, therefore, extend far beyond the immediate preservation of digital communications. They serve as a litmus test for how the government manages sensitive information in an era marked by rapid technological change. The judicial insistence on strict adherence to record-keeping laws reinforces a fundamental truth that all official government business must be documented and accessible to the public. This case underscores the ongoing tension between modern communication practices and traditional legal frameworks designed to safeguard public accountability. In closing, the developments in this lawsuit are a stark reminder that even high-ranking government officials are not above the law. The rigorous measures ordered by Judge Boasberg represent a critical step toward ensuring that the executive branch complies with its legal obligations. As the court continues to monitor the preservation of these communications, it remains to be seen whether this episode will precipitate broader reforms in how digital records are managed within government agencies. For citizens concerned with maintaining government integrity, the case highlights the importance of supporting independent oversight organizations. Whether through direct action, donations, or simply staying informed, every effort contributes to a more transparent and accountable government. In this moment of legal reckoning, it is imperative that the public remains vigilant and engaged. The outcome of this case may well set a precedent for future disputes over digital record-keeping and national security communications, reaffirming the essential principle that governmental transparency is not negotiable. This investigation, underscored by meticulous legal analysis and an unwavering commitment to factual reporting, serves as a call to action for those who believe in the rule of law. The path ahead is fraught with challenges, yet the steadfast pursuit of justice and accountability must continue unabated. As we follow this story, we remain dedicated to reporting every significant development, ensuring that the truth is preserved as diligently as the records that lie at the heart of this controversy.